from Leadingway Consultants Ltd and Saab Financial.
Yes, do everybody sit down, apart from counsel who's about to address us. Yes, Miss Bingham.
Meet you, my lords. I appear for Leadingway Consultants, and my learned friend Mr. De Cruz and Mr. Lewis appear for the respondents. These appeals, brought with the permission of Lord Justice Mayles, raise two issues of principle relating to the grant of relief from sanctions. And the first concerns the relevance of subsisting proceedings against a co-defendant, where a defendant applies to set aside a regular default judgment, and that question lies at the heart of the first appeal, centring on the default judgment entered against the first defendant, which the judge below set aside. And the second issue, which straddles both appeals, concerns the duty of candour owed by an applicant for relief from sanctions and the consequences of not being candid on an application for relief from sanctions. The path I was proposing to follow, my lord, on the first appeal concerning the default judgment against the first defendant was this. I'll start with the judgment and outline where it is that we say the judge erred. Then I'll address you on the two existing Court of Appeal authorities that touch on the role of pending proceedings against a co-defendant in a relief from sanctions context. Then I'll address you as a matter of principle on whether there should be a rule of the sort contended for by my learned friends. And then I'll turn to the duty of candour, which touches both appeals, and for that I'll need to show you a little bit of the evidence. And then finally, I'll address you on the second appeal and specifically whether the judge's decision to relieve the second defendant from the sanction embodied in the consent order was outside the range of outcomes reasonably open to him. Can we then turn to the judgment in the first appeal at page 85 of the core bundle? Page 85. This is the judgment centering on the position of the first defendant. And the position in a nutshell is this. It was an application to set aside default judgment. Applying the three-staged Denton test, the judge found that the breach he was dealing with was serious or significant, and you see that at paragraph 7 on page 88. That was inevitable. The first defendant did nothing for over 15 months after he was personally served with the default judgments. It was obviously serious. Stage 2, there was no good reason for the default, and that was conceded, as you see in paragraph 8. The evidence does not amount to good reason for present purposes, and Mr. De Cruz does not argue otherwise. So we've reached stage 3, and you see at paragraph 9, the judge rightly using the phrase all the circumstances and identifying the search for what is a just approach, which is precisely what the court ought to be doing at Denton stage 3, so there is no formal misdirection here. Paragraph 10, the judge identifies that Mr. De Cruz has sought to rely on reasons for the delay which haven't qualified as good reasons at stage 2 of Denton, and he rightly says, I don't regard them as having any real weight, and there's not much mitigation to be found there. So far, so promising, and your lordships will have the point that there is no cross-appeal as to that finding, so it's common ground that the matters relied on had no real weight. Paragraph 11, the judge nods to Mr. Cruz's argument that maintenance of the default judgment wouldn't achieve finality, a point the judge has already addressed in paragraphs 5 and 6. And so your lordships have the shape of it. Mr. De Cruz had argued that the court had jurisdiction to set aside the judgment, firstly because the first defendant had a real prospect of defending the claims, and that's the classic gateway established by CPR 1331A. But Mr. De Cruz had also argued that if he was wrong on that, there was some other good reason why the first defendant should be allowed to defend within the meaning of 1331B. And that good reason was, so it was said, that the claim against the second defendant was going to trial, so the default judgment wouldn't achieve finality. But the judge wasn't very enthusiastic about that argument, as we see at paragraph 6, because whether or not finality was achieved rather depended on whether the judgment against the first defendant was successfully enforced. If it was enforced, that would be an end of the matter, because the claimant would have been made whole. Now, Mr. de Cruz had presented the argument on other good reason by reference to two decisions of this court, which I'll need to show you, and that's Blakemores and Hussain. But you'll see that the judge recognised that they turned on their facts and didn't advance the question before him. Do you see there are two authorities that are relied on by Mr. de Cruz in particular, which have great value, but the circumstances were different. So he didn't make any formal ruling on whether the pendency of proceedings against the second defendant amounted to some other good reason within Rule 1331B. He didn't need to, because having found that the first defendant had a non-fanciful prospect of resisting the claim on the written agreement on the merits, he didn't need to go any further. A gateway had been established. So if we come back to stage 3 of Denton, which the judge is addressing at paragraph 11, he says that at stage 3, Mr. de Cruz has revisited this question of the continuation of the proceedings against the second defendant, calling on the idea that there'd be a sense of injustice if the judgment stood while the proceedings continued against the second defendant. And the judge reiterates that finality is debatable, and he's presumably there revisiting the hypothesis that he put to my learned friend in argument, namely that whether or not finality is achieved by maintenance of the default judgment against the first defendant depends on whether my client, Leadingway, succeeds in enforcing it. But he says, I go this far with Mr. de Cruz, KC, putting this in my terms, looking at this litigation as a whole, and the parties and their dealings as far as presented to me, with the default judgment, there was no real sense of the proceedings or the dispute as a whole being over. Now, pausing there, it's not clear what the judge is getting at. You won't find in any of the authorities that we're aware of any principle that a default judgment will only stand where there is a, quotes, real sense of finality, whatever is meant by that phrase. A default judgment is inherently final as between the parties thereto, at least until it's set aside. It's dispositive for the time being of the dispute. It is the trigger for enforcement action. And in that sense, was there finality? Yes, certainly. Were the proceedings continuing against the second defendant? Yes. The claimant was still seeking to achieve service on the second defendant, so the proceedings were in that sense still alive. But, my lords, that will often be the case where co-debtors are sued. The default judgment is banked and proceedings go ahead against the co-defendant while enforcement steps are put in train. Which brings us to paragraphs 12 and 13 and the judge's punchline, which is that in the present case, what justice requires is for the default judgment to be set aside, allowing the real issues for both defendants to go forward to a decision on the merits. Now, we have a number of criticisms of that, as you've seen in our grounds of appeal, but at the heart of it, my lords, there's just no reasoning. We make allowance for the extempore character of the judgment, but there's nothing here. If, on a Denton analysis, a judge finds a serious default which has occurred for no good reason, at stage 3, the court has to fasten on to something which points in favour of relief being granted, and that something has to be sufficiently weighty to counterbalance the serious, unexcused default that ex hypothesi has been found. But the judge here identifies not a single circumstance. He says the real issues in the case must be decided on the merits, but, my lords, that much could be said in every case. The essence of a default judgment is that it is a judgment arrived at without judicial scrutiny of the merits. The default judgment, it's an administrative response to a failure to respond to the proceedings. The only relevance of... Yes.
For one moment.
Yes.
First question is on a practical matter, and in part because you are going at quite a lick.
Oh, sorry.
No, but I'm just wondering, will there be a transcript?
Yes, I'm talking. There's not a live transcript, but there will be a transcript. Yes.
You've ordered one.
Yes, my lord.
Thank you. A second question, if I may. The judge is reasoning here on the assumption that the claim against the second defendant is going to continue, because he has, as I understand it, he's already dealt with the second defendant.
I think that's right. I think that was the order in which the judge...
Well, I think it's plain from his judgment
Yes.
that that's his
Yes.
assumption here. Is that
Yeah.
also your assumption?
No.
Your arguments now?
No. Well, I come to address you on this, that at this stage in an application, it can't be certain, even parking the idiosyncratic circumstances of this second defendant, where at this early stage of the proceedings, you cannot be clear whether the proceedings will carry on against co-defendants. There are all sorts of reasons why they might not, and I'll come to that when I address you on the principle here.
Plainly, if you're right on your appeal against the second defendant,
Yes.
and subject to any circularity of reasoning, then all of this goes away.
I would say so. I would say so. Well, the finality point, yes, certainly goes away, and that's what my learned friend hangs his hat on.
Well, all of it, I mean, I understand you're saying the point of principle is how do you take into account the fact that,
Exactly.
that there may be, that the claim may continue to trial
Yes,
against another defendant?
yes. That's the point of principle.
Yes. So is there something to be said for, certainly in terms of when we come to address it, dealing with the second defendant first, as the judge did?
There may be, my lord, but even if your lordships were to I put it like this, even if your lordships were to decide that default judgment shouldn't be entered against the second defendant, I would still say that the default judgment should be held against the first. Do you see? So for me...
I think it's the other way round.
Yes. Yes. Well, you mean it would be absolutely obvious if the proceedings aren't going ahead against the second defendant that we win the first appeal. I agree on that. But we don't hang our hat only on that. We say even if we lose on the second appeal. If your lordship is saying, Miss Bingham, will you kindly address us on the second appeal first?
I just wanted to understand the basis. And just one more,
Yeah.
while I'm asking you, just one more. In terms of the relevance of the continuation of the proceedings against another defendant, that must it not, to some extent, depend on the nature of the proceedings? I mean, for example, in this case, your primary case, as I understand it, certainly the way it's pleaded for, is that there was an oral agreement.
Yes.
And that was an oral agreement which was made by the first defendant on behalf of himself and his brother.
That's right.
So what one could have here is if one held the judgment against the first defendant, but the claim against the second defendant went to trial, you'd have a claim which is dependent upon whether the first defendant made an oral agreement. If that was defeated, you then have the situation where, even though the first defendant was believed when he said, perhaps in evidence, that he didn't make that agreement, you might then find that the second defendant, the claim against the second defendant is dismissed, but the first defendant would have this default judgment against him.
That's correct.
And that obviously seems to me to be at least a relevant factor to take into account.
Agreed that it's relevant, but not determinative for reasons I'll come and address you. I absolutely agree that that's something that goes into the pot, my lord. Yes. But the relevance of the merits, I was pinpointing, so we're at that stage of the judgment where the judge says, well, this must go forward for a decision to be arrived at on the merits. I was making the point that, well, it's of the essence of a default judgment that there is no decision on the merits. The only relevance of the merits on a set-aside application is that the judgment debtor must demonstrate a non-fanciful prospect of defending in order to enliven the jurisdiction. What's needed is something in the circumstances which tips the scales in favour of the grant of relief. And we say that the judgment here is impossible to reconcile with the well-established principle that a claimant is not likely to be deprived of a default judgment regularly obtained. And the judge's first error was his failure to recognise that starting point. It's common ground between my learned friend and myself that that ought to have been the starting point. Second, although the judge recognised that promptness was important and that the application had not been made promptly, he failed to afford any proper weight to that factor. And relatedly, he placed insufficient emphasis on the need to enforce compliance with the rules. And just pausing there, I'm mindful of Lord Justice Chadwick's observations about promptness in the Hussein case, and I'm going to address you on that case in a little detail. But the headline is that even assuming that promptness plays a lesser role when the proceedings are expected to continue against a co-defendant, the judge wrongly placed insufficient weight on what was in this case an egregious lack of promptness and an egregious breach of the rules. And thirdly, the judge...
Just slow down a bit, Ms. Bingham.
So one was not likely to be deprived of a default judgment regularly obtained as the starting point. Factor two, insufficient weight to the egregious lack of promptness and breach. And thirdly, the judge failed to take into account the serious lack of candour and the inconsistencies in the evidence which the first defendant placed before the court on the application. And that point touches on the second matter of principle that I told you was raised by these appeals. But as I've signalled, I'd like to turn to that issue after I've addressed you on the first question of principle, namely whether the pendency of proceedings against a co-defendant is ordinarily to be treated as a circumstance justifying the set-aside of a default judgment. And just to set the scene on this, there is, it's fair to say, a difference between my learned friend and myself as to why the judge reached the landing that he did. I say that the judge didn't accept my learned friend's submission that the pendency of proceedings against the second defendant justified setting aside the default judgment. Mr. de Cruz had certainly made that argument, and indeed that was all he was left with once he conceded that there were no good reasons for the default, and in circumstances where the judge had been underwhelmed by the mitigation offered. I say it would have been very easy for the judge to say, Mr. de Cruz says there's something called a co-defendant principle which trumps everything else at stage 3 of Denton. I agree, I'm setting aside the judgment. He doesn't say that. He offers a formulation around the absence of a sense of finality, and then he says, without identifying supporting reasons, that his view is that justice requires that the case goes forward to a decision on the merits. Now, I say that the judge was right not to recognise any so-called co-defendant principle, but wrong and outside the range of decisions reasonably open to him in setting aside judgment without articulating any circumstance which made that outcome just against the backdrop of the serious and unjustified default that had been established. But the debate around the judge's subjective reasoning is in one sense an arid one. There are only two possibilities. Either I am right and the judge had and articulated no reason that rendered it just to set aside the judgment, in which case this court would be justified in intervening and exercising the discretion afresh, and that in turn will require the court to entertain and rule on the learned friend's argument that what he describes as a co-defendant principle exists. such as justifies the cancellation of a default judgment, even in circumstances of a serious unjustified default, or the judge set aside the judgment because he was persuaded that there was such a principle which justified cancelling the default judgment 15 months after its entry. But either way, this court needs to consider the point of principle. So may I now address you on the existing authorities?
Yes.
On that point. So a learned friend hangs his hat on two decisions of this court. His position emerges most starkly from the note of objection, core bundle page 16. Core bundle page 16 at paragraph 4. Paragraph 4. So it is said in subparagraph 1 that the judge afforded due weight to the factor of promptness, but promptness was outweighed by the fact that an identical case against the second defendant would be proceeding to trial. Final sentence, my lords. This is a well-established reason for setting aside a default judgment, and Blakemore's, you see, is cited as support for that proposition. Then in subparagraph 2, Hussain and Blakemore's are cited as authority for the proposition that the court is entitled to set aside where an identical case is continuing. And similarly in subparagraph 3, reference is made to a supposed principle in Hussain and Blakemore's, and that supposed principle is now enshrined in my learned friend's skeleton argument as the capital C co-defendant, capital P principle. Just for your note, that's a paragraph 72 of my learned friend's skeleton argument, page 66 of this core bundle. You see, he elevates it to the status of an official a principle of law. And just by way of overview, we say that that's putting matters significantly too high. There's no principle, and we invite your lordships to declare that there is no principle that default judgment will be, or even will ordinarily be, set aside where near identical proceedings are going to trial against a co-defendant. Is the pendency of related...
Sorry, Bingham, again, if you could slow down.
Yes.
Yes. You're saying it in terms which invite writing down, so
yeah.
Start the sentence again.
So we say that the way that my learned friend puts it in his skeleton argument at paragraph 72 and in the note of objection that I've just been showing you, puts matters significantly too high. We say there is no principle, and we invite your lordships to declare that there is no principle that default judgment will be or will ordinarily be set aside where near identical proceedings are going to trial or may be going to trial against a co-defendant. Now,
it would be very hard to, I'd have thought, to argue in favour of such a principle. The charter for multiple defendant cases is that they could all just ignore the rules.
Indeed, my lord.
And they automatically, or almost automatically, have default or any other sanction lifted against them because it's going to trial anyway.
Exactly.
That can't be right.
Exactly so, my lord. So certainly the highest that my learned friend puts his case must be wrong. There is no principle that there's a get out of jail free card for people where they can point to a co-defendant. Now, is the pendency of related proceedings a relevant factor which the court's entitled to take into account? Yes, and for two reasons. Firstly, because finality and speed are among the imperatives which drive the availability of default judgment. And to the extent that you might achieve finality by maintaining a default judgment, that is a circumstance which the court is entitled to weigh in the balance when deciding whether to set it aside and in deciding where the balance of justice lies. And likewise, and this is picking up on a point Lord Justice Phillips raised a moment ago, the pendency of related proceedings may be thought a relevant circumstance because it's at least arguably an unattractive outcome for a default judgment to be maintained against a first defendant, say on the footing of a contractual obligation, only for a co-defendant to establish at trial that the contract underpinning the claim was void for duress or to be interpreted in a way that negates liability. Now, I say arguably unattractive. It would be wrong to put it higher than that. Where the first defendant has to pay up and the second defendant's defence is later upheld, it's not a case of the law being brought into disrepute, though one can see that it might be portrayed like that down the dog and duck. Properly analysed and understood, there is no inconsistency in the maintenance of a default judgment based on a contractual claim and a later finding by the court in proceedings pursued against a defendant who was party to the same contract that the underlying contract was void. In the one case, the court is exercising an administrative power to require payment in circumstances where a defendant has not responded to the service of process in the time frame established by the rules. In the other, the court is making a reasoned finding on the basis of evidence and argument that it's heard, and plainly the results may differ. There is no repugnancy in that.
Can I turn your proposition round? Is there a principle that the pendency of other proceedings is, well, there are no circumstances in which the pendency of other proceedings would justify relief from sanctions? Is there a principle to that effect?
There are no circumstances.
In other words, the opposite of what you're submitting, the respondents are advancing.
Well, it's a difficult question, that, because stage 3 of Denton. Sorry.
You accept it's relevant.
Yes.
So if it's relevant,
could it be self-sufficient? Could it stand on its own and be the only factor? I doubt it, my lord. But that's partly because stage 3 of Denton is a melting pot. You're never really going to have just one factor. But I probably would go this far in response to my Lord Justice Moylan's question. If it were it could never be the only factor. If all other factors told in favour of the default judgment being maintained.
So your principle is the default judgment will be, or ordinarily will not be, set aside where you have near identical proceedings.
I doubt whether it's constructive to speak in generalisations for this reason, that it's every case is going to turn on its facts. When you're at stage 3, you don't lose sight of the extent of the default. How serious was the breach? Now, if you've got a modest or marginal breach and a good explanation, I well recognise that the pendency of proceedings against a co-defendant could tip the scales in favour of setting aside the default judgment. So I wouldn't say never say never. I recognise it's got to go into the pot. But if all other matters told strongly in favour of maintenance of the default judgment, could the mere pendency of a case against a co-defendant, which realistically might or might not go to trial, tip the scales? I doubt it. But as I'll show you when we come to the cases, there may also be a difference, my lords, between a case which is at an embryonic stage, such as this case, where really only a crystal ball will tell you whether you're going to trial, and a case we'll see it in each of the Hussein and Blakemore cases. In one of those cases, a pre-trial review had been had. The matter was right for trial. It was definitely going for trial, and you can see a difference between a case that is on the doorstep of the trial and a modest delay that has been excused. Well, I can see in those circumstances quite a compelling argument that it's a weighty factor to be put into the pot. But in other cases where you've got an egregious default and there is no certainty that the case against the co-defendant will proceed to trial, I doubt that it could tip the scales. But in answer to Lord Justice Moylan's question, as I say, it's not in my submission perhaps even possible to lay down a general principle as to the weight to be afforded to that factor at stage 3, because each case must turn on its facts.
You've trailed the Blakemores and Hussein cases.
Shall we go to them now?
Yes,
Yes.
let's
So
do it.
Blakemore's, yes. So I think the high point of my load of friends' submissions is Blakemore's. In your lordship's bundles, it's tab 15. Tab 15 of the joint authorities bundle, page 251. So Blakemore's. Now there, 3 unrelated residents of a village in Derbyshire were said by the solicitors Blakemore's to have joint and several liability for certain legal fees. And one of those 3 defendants, Mr. Balkin, failed to engage with the proceedings because he didn't receive the claim. He'd moved out of the house that the papers were sent to, and he only learned of the proceedings a year after default judgment was entered against him. And then he acted reasonably promptly in applying to set aside. Now, the case against his co-defendants was proceeding to trial, and the question was, should the judgment be set aside under Rule 13.3, read in conjunction with the relief against sanctions regime? And we can pick it up paragraph 58, please, my lords. So it's page 267 of your hard copies, paragraph 58, which is the judgment of Lord Justice Voss, with whom the other members of the court agreed. And can I ask you to read paragraphs 58 to 61 to yourselves, please?
Is the date wrong? It was judgment 2013.
That's right, my lord. On the law report, it's 2015. Well, the report is.
No, sorry, I meant paragraph 59.
Yes.
Refers to the judgment, default judgment, having been attained in February 2014.
Paragraph 6.
That says 13.
Yes, I'm sorry, my lord, was spotted.
That's what I meant.
So I'm so sorry, yes.
So it's a solicitor's claim for
For fees, driving several liability.
against a number of lay clients,
Exactly.
acted for all of them. The claim Justice Voss describes as a very large claim for fees. Mr. Balchin seems to have had very good reasons for
Very good reasons.
being out of time, and the court finds it would be quite unfair that he should in effect become liable for the whole of the solicitor's fees without having a chance to dispute quantum or anything else, and let the other clients could get off scot-free.
Yes, that's exactly right, my lord. An easy case, but my learned friend, I think, points in paragraph 58 to the sentence. Moreover,
Yes.
moreover, it would, in my judgment, be unjust.
Yes.
And it's a point which the judge.
Clearly would on the facts of this case.
Well,
but
indeed, my
you
lord.
say that that doesn't lay down a general principle.
That's right, and the judge does return to the point, in fairness to my learned friend, at paragraph 61 of the sort of perceived unfairness, and he founds on these passages, and these passages alone in support of his proposition that it is, in his words, a well-established reason for setting aside a default judgment that identical issues are going to be explored in pending proceedings. But this case, as my lord points out, this case establishes no such proposition. This is a case where applying the Denton criteria, including critically by asking was there a good reason for the delay, the court found that there was, and that Mr. Balkin had acted with reasonable expedition upon learning of the proceedings, taking into account what the court described as his very special circumstances. Now, does the court nod to the circumstance that the co-villagers are heading to trial? Yes, that's entirely proper, but that's not treated as something that eclipses the Denton analysis or something that forms a self-sufficient ground for setting aside the default judgment. And you see that perhaps most clearly in paragraph 58, and in particular in the final sentence of paragraph 58. The shape of the paragraph is Lord Justice Voss observing that it's common ground that the relief from sanctions regime applies. Nevertheless, let's start with Rule 13.3 and real prospect of success. Then he remarks on the injustice of depriving Mr. Balkin of the right to defend. But note the final sentence, notwithstanding this view, it's necessary to approach the matter as the court laid down in Denton. And this sort of touches on the question put to me by Lord Justice Moylan. It's very hard just to isolate this factor and divorce it.
No, I understand that, which is why I asked the question. But if you look at this case, yes, the Denton exercise has to be undertaken. But as to the third stage, paragraph 61, the factor that is alighted on is that it would be unjust, as I have said, for the judgment to stand against him while the co-defendants were allowed to proceed in their defence. So in that case, that was the relevant third stage factor.
Well, what I would say, respectfully, my lord, is he's not purporting to say, well, where a defendant can point to proceedings in the pipeline, never mind Denton and relief from sanctions, that is in itself a well-established reason for setting aside. The pendency of proceedings isn't being held up as a trump card. Lord Justice Voss is simply putting the proceedings into the pot, and rightly. But the primary reason, my lord, why default judgment is set aside here is because the default was modest and there was good reason for it. That's what I take from this. I take that Blakemore's doesn't do the heavy lifting that my learned friend asks it to do. Could we next look at Hussein, which is the other case, tab 3 of your authorities bundle, tab 3.
Yes.
So Hussein is not authority for the proposition that where default judgment has been entered, it'll be set aside if the same issues are due to be ventilated in a forthcoming trial against a co-defendant. Now, Hussein was in many respects an easy case in that all parties were agreed that the default judgments that had been entered against the school governors couldn't be allowed to stand. All parties invited the court to set aside the default judgments, as I'll show you. So Hussein doesn't really usefully advance the debate about the burden faced by an applicant to set aside. It came before the court, I might say, under the old Rule 3.9, the checklist of 9 circumstances that was abolished in 2013. And of course, it antedated Mitchell and Denton, which are now the gospel in this area. To be clear, I don't say that Hussein would have been decided any differently under today's regime. Hussein didn't really involve a decision as such. The order was entered by consent. It was an easy and obvious case where judgment had to be set aside. There's only really one observation of interest in Hussein, and that is in the judgment of Lord Justice Chadwick at paragraph 29 on hard copy page 40. That's paragraph 29 on hard copy page 40 in the body of the judgment of Lord Justice Chadwick.
So,
Let me put it briefly. Sorry.
I haven't looked at this case, or at any rate not for a long time, so just tell us a bit about it. Personal injury case against effectively 3 defendants.
Yes, let me put it into context, my lord. Facts were every parent's nightmare. Little boy goes to his karate class in a dance hall at the local community centre. There is a stack of crash mats piled up in the room. Little boy climbs to the top of them and sits himself down. Adjacent to the stack of mats is a window which is not locked shut. He falls out, sustaining ghastly injuries, including injuries which impact his prospects of employment in later life. When the boy reaches his majority in 92 and sues for damages, the first key question is who is to blame? Is it the council, which owned the building? Is it the karate instructor who took the class? Or, as the council contends, both by way of defence and by way of Part 20 proceedings, is it the school which occupied the dance hall pursuant to a deed between the council and a body known as the Education Assets Board? Now, initially, proceedings were brought only against the city council and the karate instructor. But once the council had articulated its defence, namely that the relevant occupiers were a local school, and once the council had issued Part 20 proceedings against the unnamed governors of that school, Mr. Hussein joined the governors as defendants to the main action. The governors failed to respond to correspondence, and judgments were entered against them both in the Part 20 proceedings and in the main action. Now, those judgments weren't immediately enforceable for at least 2 reasons. First, because the governors weren't specified or named, and you see that on paragraph 23. But secondly, because all questions of quantum remained live. Quantum in the main action was bifurcated, so the judgment entered against the school governors in the Part 20 proceedings provided simply that the governors would be bound by any judgment or decision in the main action. So that, my lord, was the context in which the governors applied to set aside. The judge having refused to set aside, the governors appealed, and we can perhaps pick it up at paragraph 28, which is hard copy page 40, where Lord Justice Chadwick is running through the test as it then stood. So he addresses Rule 13.3 and the requirement that the court have regard to whether the application has been made promptly. He observes that the application has not been made promptly. And then the interesting and germane dicta, my lords, are at paragraph 29. But it must be borne in mind that this was not a straightforward contest between a claimant and a single defendant, where the effect of a default judgment, if allowed to stand, would be that there will be no trial. In the present case, on any basis, there will be a trial between the claimant and the council and Mr. Coulson, the karate instructor. And at that trial, the court will have to investigate the issue which would arise if the governors were taking part in that trial. That is to say, who, as between the council and the governors, or perhaps the governing body, was to be treated as having responsibility for the premises for the purposes of the 1957 Act. The court would have to investigate that issue because the issue lies at the heart of the council's defence to the claimant's claim. And then these are the critical words. So although a factor to be taken into account, the failure to act promptly of itself must, as it seems to me, carry rather less weight than it would in a case where the effect of the default judgment, if left undisturbed, is that there would be finality. And to be clear, my lords, we agree with this statement. It makes good sense. A failure to act promptly is just one factor, albeit an important factor. And one of the reasons why it's important is because one of the court's concerns is to achieve finality at the earliest opportunity. And to the extent that a party's lack of promptness has had no or minimal bearing on the broader timetabling of matters, that is a circumstance which the court will weigh in the balance in deciding whether to grant relief from sanctions. Now, in Hussein's case, the position was particularly stark for two reasons. First, the default judgment was somewhat notional. There was no world in which the claimant could cash in the judgment until quantum had been decided in the main action. So as a piece of paper, the default judgment was of limited value, at least in the short term. And secondly, the key dispute, which was going to be decided in the main action, was whether the premises had been occupied by the council or by the governors. And it would have been rather odd for that debate to be staged in the absence of the governors and their disclosure. It was obviously desirable that the governors had a seat at the table. And that was quite apart from the fact that the default judgments, as everyone agreed, appeared to have been entered against the wrong people, the school's governors as at 2004, when the proceedings were instituted, rather than the corporate governing body which ought to have been sued, or at least the governors as at the time of the accident in 1992. I should perhaps just show you that and the further passage which my learned friend would like to show you. So it's at page 42 of the hard copy bundle. Page 42, my learned friend has highlighted paragraph 36. So can I ask you to read that? And then paragraphs 37 and 38. So you have the proper context of this, 37 and 38, as well as 36, please.
Yes.
Yes, so you see that in fact the court doesn't indicate a view on whether it would have set aside the judgment because it was common ground that the judgment couldn't stand. I've shown you Blakemores and Hussain. As you know, I say that the judge below didn't treat Blakemores or Hussain as authority for the proposition that the pendency of related proceedings is a panacea for the defendant who seeks to set aside default judgment. But the question that arises squarely in this court, treating the question as, well, free from authority, save to the extent of the limited dicta that I've shown you in Blakemores and Hussain, and approaching the matter as one of principle, should the court declare it to be the law that ordinarily the pendency of proceedings against a co-defendant is a factor which will render it just to set aside a judgment, even where there's been a substantial and unjustified delay. We say no, the pendency of proceedings is not a matter which should ordinarily excuse substantial unjustified delay or lead to relief from sanctions in the context of a set-aside application. It is just one factor which the court is entitled to consider at stage 3 of the Denton analysis. In an otherwise very finely balanced case, where the delay has been modest and there is some explanation for it, subsisting proceedings might come to the judgment debtor's aid, but it is not in itself a circumstance which could ever in isolation enable the court to overlook substantial unjustified delay. And why do I say that? There are 6 key reasons, and I'll take this slowly because this is the meat of the appeal, the first appeal, my lords.
I'm sorry to ask the question again, but
Yes.
that is the principle that you are advancing.
That it is not that the pendency of proceedings.
Well, what you said is that in a finely balanced, it's only, I would add, your submission is it is only in a finely balanced case, and the delay sorry, can't even read my own writing now. In a finely balanced case, and
Where the delay has been modest and there's some
Yes,
explanation
thank
for
you.
it.
it might.
It might come to the. It
Yeah.
might come to the. And I can see your lordship seeking to steer me towards a landing. I think
No, I'm not.
these-
I'm just asking whether you're advancing that as a principle or how it fits in with your case.
Well, we say there is no principle that it will or that it ordinarily will, and we say the limit of it is that it is something that can go into the pot at stage 3 of Denton. And I say there are 6 key reasons. And can I run you through the 6?
6 reasons why it can be no more than that.
Why there isn't a principle of the sort that my learned friend contends for at paragraph 72 of his skeleton and in the notice of objection that you've seen. So the 6 reasons, right? I just look up my. Do your lordships have white books there?
Yes,
Yes.
certainly this one is quite old.
A volume 1. Well, we'll see. So, I don't think the relevant rule that I'm going to point to has changed, though perhaps.
no, it's not in the authorities bundle.
It's always the way when you photocopy
always
little
the
bits of the white book, you don't have the right page. But let's see. So the 6 key reasons. The first simple point is that the rules expressly contemplate that default judgment will be available in cases involving joint debtors, and that's CPR Rule 12.9. CPR Rule 12.9. In my white book, it's page 445 of Volume 1.
Look, if you're going to be referring us to passages from the white book, we must get.
Right, I'm grateful, my love. I'll organise for this rule. Can I just read it to you now, because it's just a sentence. It's Rule 12.9, and it provides as follows: a claimant may obtain a default judgment on request against one of two or more defendants and proceed with the claim against the other defendants. That's in material part, that's what it provides. A claimant may obtain a default judgment on request against one of two or more defendants and proceed with the claim against the other defendants. We'll just get that, copies of that rule. So the rule makers, my lords, have addressed the circumstance that one defendant will find himself on the end of a default judgment while a co-defendant proceeds to trial, and they're satisfied that that's an acceptable state of affairs. And I highlight that just because what we witnessed in the Blakemore's case was the point that Lord Justice Phillips was raising, and it's the court querying the justice of shutting out one defendant from defending in circumstances where his co-defendants were imminently off to trial. And it was understandable, my lords, in the circumstances of that case that relief was granted. But it is inherent in the availability of default judgment for joint liability cases that there may be situations in which one defendant is ordered to pay up while his co-defendant proceeds to make good a defence at a later trial on the merits.
And with its joint liability, entering judgment against one defendant might be disastrous.
In that,
Well, if it's joint, you have if you have judgment against one, it probably precludes you proceeding against the other defendant.
well, not till you've enforced, my lord. Not till you've enforced. And in fact, regularly, a claimant will enter judgment against multiple parties simultaneously, up to 10 or 11 times the value of its claim, and it can then pick and choose in terms of who is the low-hanging fruit in terms of enforcement. There's no merger at the point of the entry of judgment.
Well, it may be that probably doesn't matter for these purposes, but it's. By all means, we can show it, but this is absolutely basic stuff, isn't
Yes.
it? I mean,
Yes.
Particularly in a commercial court where you may have multiple defendants in all sorts of jurisdictions, you will often have some defendants not served, some defendants default judgment, and you'll often go to large trials where there's already default judgment against some of them. I mean,
Exactly, Molly. It is very basic.
this isn't very. This doesn't really help with the issue that we're addressing, which is what do we do here?
Well, I wonder, my lord, because part 12 and the rule that I'm showing you assumes that judgment can and will be entered as an administrative matter and without judicial scrutiny. Rule 12.9, as I say, specifically accommodates the eventuality that proceedings will go ahead against a co-defendant, from which it must follow that the mere fact that a defendant might end up paying under a default judgment is a circumstance in circumstances where the court may later rule that no relevant liability existed, is a feature of the system. And that being a feature of the system, my lord, it can't also be a matter which of itself or ordinarily justifies setting aside. It was open to the rule makers to carve out joint liability cases from part 12, and that's not what they did.
Forgive me, the fact that you can enter default judgment against somebody and proceed against the other defendants doesn't say anything about the relevance of there being joint defendants when you apply to set aside the judgment. And by definition, you have the power that there is the ability to enter the default judgment, otherwise you wouldn't be engaged in the issue of whether you can set aside judgment.
That's right. Well, I suppose I put it no higher than this, that the availability of default judgment in co-debtor situations suggests that it's not an absolute bar. Perhaps the position is better put by the Supreme Court in. It's not a huge point, but it's better put by the Supreme Court in. Now I've cited this. Now, which is it? It's the Global Torch case, my lords. I mean, it's a small point, but tab 13 of your bundle.
Just before we go to any authorities,
Yes.
you showed us 12.91. Is 12.92 relevant?
Advice of default judgment. Well, does it help on this application that the court has, you know, procedural power to look at it and see how best to manage the proceedings? It's perhaps not determinative. You would expect the court to have that power, and it has. But it's a short point, I think, made by Lord Neuberger in the Global Torch case. There is just the fact that proceedings. The short point is this: that the Rule Committee hasn't excluded from the default judgment regime cases of joint liability, and it doesn't go much further than that. But it's just pinpointing that they could have said, well, in joint liability situations, there's this uncomfortable reality that, at least in theory, there might be the maintenance of a default judgment where later the contract is, say, the underlying contract is found to have been void. That's so unattractive. We won't allow it to happen, but the court doesn't. But as I absolutely take Lord Justice Phillips' point, that it doesn't give that doesn't help us with, well, in what circumstances or how should the court treat the circumstance. So can I go to number two? Number one is just showing you that it's there on the jurisdiction. Number two is that Rule 13.3 directs the court's attention specifically to the promptness with which the set-aside application is made. I think we do have Rule 13.3 in the bundle at tab 33. Tab 33 of the joint authorities. So Rule 13.3 at tab 33 directs the court's attention specifically to promptness. Now, as you know, the relief from sanctions regime is superimposed on the requirements of Rule 13.3, as decided by this court in the Karate Federation case. But the first port of call is Rule 13.3, and there is just one matter which the court is expressly required to consider, namely promptness. Now, if in fact, my lords, the rule of thumb is that a default judgment debtor will be entitled to set aside judgment by the simple expedient of pointing to proceedings pending against his co-defendant, then it is hard to see how promptness is being afforded the weight or prominence which the rule makers appear to have contemplated. The rule makers have shone a spotlight on the conduct of the default judgment debtor. They've said something you must look at is whether this judgment debtor moved swiftly to set the judgment aside. But the court on the learned friend's case would be relaxing the rules for a reason quite unconnected with anything done or undone by the judgment debtor. It would be relaxing the rules by reference to the contingency that the claimant had elected to proceed against a co-defendant within the same proceedings. Now, I don't say that subsisting proceedings, as you know, can't enter the analysis at Denton Stage 3. I do say that keeping faith with Rule 13.3 here, those subsisting proceedings can't muscle in at Stage 3 and eclipse a serious lack of promptness within the meaning of Rule 13.3. So that was the second rule to highlight, that Rule 13.3, directing the court's attention to promptness. The third point is that in the main, the court encourages a canalised approach to multi-party litigation where overlapping issues are raised. And I'm not here just referring to cases where the defendants are jointly and severally liable. Wherever the subject matter is related, the court strives to avoid inconsistent judgments on the merits, so it consolidates proceedings that involve common issues. It assumes jurisdiction over necessary and proper parties. Efficiency is the order of the day. Now, fragmentation of proceedings is discouraged, but a rule which provides that a default judgment regularly obtained is inherently vulnerable wherever a co-defendant is actively participating in and defending the proceedings is inimical to the one-stop shop principle and the goals of efficiency and canalisation. In effect, a claimant who very sensibly has sued a group of defendants in a single set of proceedings may find his default judgments against one or more of them defeated by the ongoing pursuit of the proceedings against other defendants, a predicament he wouldn't face if he'd sued the defendants separately. And I say it shouldn't be the case that a regularly obtained default judgment stands or falls according to the happenstance of whether the judgment debtor has been sued alongside another defendant or defendants. That's number 3. It's the claimant's prerogative, obviously, to proceed against other defendants while he devotes time and money to the enforcement process. He's very sensible to do just that, because you never know who'll be good for the money or where you'll find the assets. Perhaps more importantly, a claimant who's sued multiple defendants has no real choice but to carry on against the co-defendants while he sets about trying to enforce against the first defendant. The court is not going to stay or suspend proceedings against co-defendants indefinitely. An enforcement can take years, but if the claimant discontinues against the other defendants, it's not obvious that the claimant would ever be able to resuscitate the claim against them down the line if enforcement against the first defendant fails. He might be out of time by then, but even if not out of time, he'd probably face a Henderson-style argument that he was abusing the process by blowing hot and cold and stopping and starting. So he's got to carry on against the co-defendants. Why, we ask rhetorically, should a default judgment regularly obtained be jeopardised by the circumstance that the claimant and its legal team are very sensibly proceeding against all available defendants while seeking enforcement against the judgment debtor? There's nothing to commend that sort of regime, we say. That's number 3.
If a claimant has obtained a default judgment against D1, can't proceedings against D2, D3, D anybody else be stayed by agreement?
Well, would they be? And would that be fair on the other defendants?
Well, why wouldn't they be? By agreement.
Well, then you turn it on the happenstance of whether the other defendants are happy to play ball. But would it even be satisfactory from the court's perspective for these proceedings to be on ice, potentially for years, while enforcement steps are taken?
I don't know. I don't have to answer the
No,
question.
of course, no, of course not. No, I'm just running with your lordship's hypothesis of, well, why don't you just put the proceedings on ice, or mightn't the parties agree? Well, in some cases, my lord, they might agree. It wouldn't be in some cases they wouldn't, and if they did, from the court's perspective, I query whether that would be satisfactory, having very stale proceedings on ice to abide the possibility that enforcement will succeed. So that's point 3. Point 4, and Lord Justice Phillips sort of touched on this when he talked about a charter for delay. There's lots that's offensive about a regime which treats as vulnerable a default judgment where related proceedings are ongoing. First is that a claimant can spend hundreds of thousands of pounds chasing enforcement only to find its default judgment overturned 6, 12, 18 months into the process. And you might say, well, delays of more than 6 months or a year in applying for default judgment are rarely going to attract relief from sanctions. We'd respectfully agree, but of course that's precisely what's happened here. 15-month delay. So the court is saying, no matter that 15 months have passed, no matter what stage you may be at in the enforcement process or in what jurisdiction, all of which is, of course, privileged and very sensitive, because nobody wants to alert the judgment debtor as to the enforcement steps that are in motion. But, you can never treat as safe a judgment for so long as proceedings are pending against a co-defendant. We say that can't be right, at least where no good reason has been shown for the delay. And fifth, and this is really on Lord Justice Phillips' point, we'd highlight that the default judgment regime is a paradigm example, compliance with its rules, the court insisting on the efficient conduct of litigation at proportionate cost. And that's not judicial musculature, as one judge has described insistence on compliance. It's keeping an orderly shop. Litigants fail to respond to process at their peril, and a rule which in effect offers an escape hatch where proceedings are pending against a co-defendant does nothing to encourage compliance with the rules. It's not faithful to the post-Jackson reforms culture. It's not faithful to the relief from sanctions regime with its emphasis on compliance with rules. It is a charter to sit back. So that was the fifth point. And then the sixth and final point is that a rule which affords significant weight to the pendency of proceedings against co-defendants takes as its starting point an assumption that those extant proceedings will in fact continue to trial, but in many cases that assumption won't be justified. So let me develop this briefly, because it's important to recognise the limits of the dictum of Lord Justice Chadwick in the Hussain case. The observation in Hussain was that promptness is of less importance where the dispute is inexorably heading to trial, because there's no saving of court resources and the claimant isn't being spared a trial. Holding the default judgment won't result in finality because there'll be a closely related trial anyway. Okay. Now it's easy to see why the court took that view in Hussain, because in Hussain, statements of case and witness statements had been exchanged. There'd even been a pre-trial review. So that case was obviously headed for trial.
Well, it was headed for trial about a week before the decision.
Exactly, my lord. And it was definitely fighting. Likewise in Blakemore's, though to a lesser extent, by the time that the default judgment came to Mr. Bolkin's attention, the case was fully pleaded. There'd even been a summary judgment application. Now, the proceedings were in full swing and walking and talking like a dispute that was on its way to trial. But very often, my lords, that won't be the case. So take your ordinary case where an application to set aside is made just a month or 2 months late. Okay, in that scenario, a jurisdiction challenge by co-defendants might be pending, or, as here, the claimant may still be in the process of trying to serve some of the parties. And in both of those scenarios, there won't be any pleaded defence. So how is the court to set about weighing the likelihood of the proceedings taking off in relation to co-defendants at that early dawn of the proceedings? You know, is it to do a scratch and sniff of the jurisdictional position? Is it to anticipate knockout defences that might be submitted by the other defendants? We say not. What, and perhaps all, that can be said with confidence is that the overwhelming majority of cases don't proceed to trial for one reason or another. Claims are regularly knocked out summarily or on jurisdiction challenges. Claims are discontinued where a particular piece of evidence comes to light. So if you're faced with a relatively prompt application to set aside, it frequently won't be possible for the court to say with any confidence whether the proceedings will move forward, whether in the short or the long term. So the question of whether holding the default judgment will in the fullness of time result in finality is anyone's guess. And it follows that a rule which says, well, if another defendant has been named, the court can proceed on the basis that it may as well overturn the default judgment because holding it won't achieve finality, is a rule with a very wobbly foundation. You can't safely anticipate whether the result of holding a default judgment will be to achieve finality. The most that you can say is that a rule which holds a judgment debtor to his default judgment is apt to promote finality, at least in respect of the claim as between the claimant and that party. And I'd only add to that one that this case well illustrates the fact that only a crystal ball will tell you whether the proceedings against the co-defendant will proceed to trial. Obviously, if I make headway with the second appeal, the proceedings against the second defendant aren't going anywhere. But even if you're against me, my lords, on the second appeal, there are all sorts of reasons why the proceedings against the second defendant might fall away if it transpires, my lords, that the assets in the estate of the late Fadi Michel Saab are very limited, or if some creditor fastens on those assets in the next year or so. We may, of course, discontinue because we form the view that the proceedings aren't worth the candle. The second defendant may argue in his defence that the first defendant had no authority to bind his father to the oral agreement. And in fact, the first defendant has already hinted as much. You may have seen that in the supplemental bundle, but he may seek to argue that the signature on, sorry, were you, no. He may seek to argue that the signature on the written agreement isn't his. I mean, who knows? It's far too early to tell. But what is for sure is that if we hold the default judgment, we have the option to continue to seek enforcement and to get proceedings launched against the second defendant. Now, if you take away our default judgment and we conclude 6 months from now that the proceedings against the second defendant aren't viable, then we'll have to bankroll a full trial just against the first defendant. So rather than having finality, by which I mean the finality involved in having no trial against the second defendant and a final default judgment against the first defendant, we will be clogging up the commercial court with a claim against the first defendant. You will have reduced our options and deprived us of potential finality to our prejudice. So, my lords, just looking at the time, those are the 6 points of principle. That's why we say there is no rule to the effect that the pendency of proceedings against a co-defendant will ordinarily palliate a serious default. And that is principally why we maintain that in this case, the only reasonable outcome that was open to the judge was to refuse to set aside the judgment for the simple reason that no circumstances had been demonstrated which outweighed the serious unjustified default that was in play. But there is a further reason, which brings me to the second issue of principle raised by these appeals, and that is the role that candour has to play on an application for relief from sanctions. But my lords, would that be? Do you try to take a break in the mid-morning, or you go straight on?
Let's go straight on.
Straight
Carry
on.
on, Miss Speaker.
Right, yes. So candour. So this point about candour straddles both appeals, and the short point that we urge the court to underscore in its judgment on these appeals, I hope uncontroversially, is that an applicant for relief from sanctions must be candid with the court. Where there's been a breach of the rules, it is incumbent on the applicant for relief to give a full and frank account of how the state of affairs has arisen. And if he fails to do so, that is a matter that can and generally will be brought into account when the court decides whether to grant relief. My lord, that's the headline. And as to the relevance of that duty of candour to the outcome of the appeals before you, I say that the first defendant's lack of candour is a yet further reason why the default judgment against him should be allowed to stand. And that's grounds 2E2 and 3 in the core bundle at 14.3. And in the second appeal, centering on the second defendant's application for relief from sanctions, the judge's treatment of the second defendant's lack of candour was one of 5 respects in which the judge fell into error. So can I start, my lords, by showing you the evidence before the court relevant to candour? And taking it chronologically, there was pre-action correspondence between the parties in July and August of 2021.
Did the judge deal with this?
Did the judge deal with candour? Well, he did touch on the second defendant's lack of candour in his judgment, yes.
But
And
not the first defendants.
he didn't address it expressly in his judgment relating to the first defendant.
And it was relied on.
It certainly was, my lord, yes, exactly. And so you see the lack of candour is engaged at grounds 2E2 and 3 of our grounds of appeal, page 14.3 of the core bundle. It was absolutely relied on below, yes.
Can I just ask you so we get our bearings?
Yeah.
You recognise there's a duty to give full and frank disclosure on without notice applications, and in public law, in some situations, it's a duty of candour. But are we here? Is there any duty of candour? Isn't it just simply that the party is making an application for relief from sanctions? The burden is on them,
Yes.
and they must satisfy the court to grant relief, and the court will obviously not grant that relief if they think that they haven't been told the full circumstances.
Exactly, it's not more complex than that. I don't put it higher than that, my lord. I just say that part and parcel of the burden is to be candid. If the court feels it hasn't had a full and candid explanation for how this unsatisfactory state of affairs has arisen, that should ordinarily result in the refusal of relief.
I share my lord's hesitation about this, unless you're about to show us an authority in which the duty of candour, the phrase duty of candour has been applied to what you're describing. It doesn't seem to me to have anything to do with it. In the duty of candour principle, going back at least to the Moylan case in 1917, if not earlier, it is that the claimant has, usually the claimant, has failed in his duty to, when a applying for anything without notice to the other side, to explain what the other side might say if they're there, to explain potential weaknesses in the case and so on. And the judge, if that isn't done, is being misled by the claimant's lack of candour. But here, you're simply saying that if a defendant applying relief from sanctions doesn't give good reasons why the delay has occurred and so forth, then it's likely to be a weak case. But that doesn't seem to me to engage a question of candour. It's just that you need reasons. You say we'll come to it. You're about to come to the second defendant's case, but you say that the first defendant has given very weak or non-existent reasons as to why nothing was done for 15 or 16 months. But that's not candour.
Well, I wasn't, and I apologise, I'm not intending to use the phrase duty of candour as some sort of term of art equivalent to the ex parte duty that my Lord Justice Phillips is hinting at. I think it is no more than this, that ex hypothesi on these applications for relief, you've got an unsatisfactory situation. And it's not just about has this applicant for relief shown a good reason. The applicant may or may not have shown good reason. It's in his application and his evidence should explain how this has come about in a frank manner. And when we come to look at the evidence, I'll show you what I mean by that. If an applicant is visibly coy and holds back what is obviously significant detail, the result in the ordinary case is likely to be, we say, and ought to be, that relief is refused. But I'm not seeking to package it as some brand new duty adding a layer of law. I'm simply, it is part and parcel of the burden. I don't think it's more technical.
It is probably a burden rather than a duty. I mean, a defendant applying to set aside judgment isn't under a duty to the court to give any reasons at all. But if he doesn't, then the application is likely to fail. Shall we go to the material which you say it is unsatisfactory?
Yes. All right. So we have the letter before action. So we're going to look now at the supplementary appeal bundle. That's where the evidence, and I take this as shortly as I can.
Yes.
Page 226 in the supplemental bundle. This is the letter before action. And your lordships will know it's addressed to the two defendants at separate addresses in Cyprus. And the address used for the second defendant is the address that he filed with the Cypriot court as his address to be used in connection with the administration of his father's estate. Now, we know, my lords, that this letter reached the first defendant because he responded to it a few weeks later. Let me take you straight there. It's at page 249. This letter before action includes everything you'd expect it to contain. 249 is the response. And I ask you to note 2 points. Paragraph 2, Mr. Saab is immediately alive to the prospect of a jurisdiction challenge, and I'll be coming back to that. And then in the body of the letter, he just takes issue with the conclusion of the oral agreement. But note the final paragraph. We do not resile from the commitments made in the letter of 22nd of May 2017, which is the written agreement relied on in these proceedings, additionally to the oral agreement. And the trust has been established. Clearly, there have been some delays created by economic and political difficulties in Lebanon, but we have every intention to meet the commitments as per the May 2017 letter. And I emphasise the plural pronoun we, because in circumstances where Mr. Saab's brother had been dead for over a year when this letter was written, the intention can only have been to communicate the joint position of Mr. Saab and his nephew, who was the addressee, the second addressee of the letter before action that I just showed you. So I say this letter communicates the joint position of the two defendants, which entails, of course, that the letter before action had been discussed between them. And I labour that because when you come to consider the second defendant's position, I say it's not irrelevant, my lords, that he was alive to these threatened proceedings way back in mid-2021. There is, I might say, unchallenged evidence that the second defendant separately received the letter before action. So both defendants receive the pre-action correspondence and they respond jointly in mid-August. Next is service. My lords, 211 of this bundle, please. We have the affidavit of service of the proceedings on the first defendant. Paragraph 3 tells us
William,
sorry.
have you set out this sequence of documents in your skeleton?
Well, we've got it all in the, I think we've got all of this in the chronology, my lord.
Right.
Yes, the chronology in the proceedings. So
Sorry, which page were you?
We are at 211, my lord, which is the affidavit of service on the first defendant. And paragraph 3 at page 211 tells us that personal service was achieved on 24th of March 2022. But over the page, can I ask you to note paragraph 4? Mr. Saab accepted delivery but refused to sign an acknowledgement of service on receiving the documents. And I highlight that because in my submission it's the conduct of a litigant who wants to muddy the waters. It's the cynical conduct of someone who wants to reserve to himself the ability to deny that he's received the documents. There is no honest reason for refusing to give a courier a signature. And certainly Mr. Saab has never identified such a reason. He's never explained why he thought it appropriate or proper to take the documents but refused to sign for them. So he has the claim, the response pack, the application for service out and supporting skeleton and so forth. And I highlight that because as you saw from the pre-action correspondence, Mr. Saab was at all times alive to the potential for a jurisdiction challenge. He now sees that the claim has been issued and permission has been granted to serve out, but he does nothing. Now, time expired for acknowledgement of service towards the end of April, and Mr. Justice Jacobs entered default judgment, and that default judgment was personally served on the first defendant on 26th of August. If you have page 215 there, 215, that's a second affidavit of service from the same Cypriot bailiff. And you see again at paragraph 4 that the bailiff gets the same treatment. Mr. Saab takes the documents, but he refuses to sign for them. And will you note in passing, my lords, that the package includes all the materials that went before the court in the context of the application for default judgment, including a skeleton argument and a witness statement. I'll spare you those documents, but if we just turn up the court's order at page 81, this is the court's order.
So, core bundles. Or
No, supplementary, this is all, yes, all is supplemental, my lord. Court's orders at page 81, you see from the recitals that there'd been a paper application dealt with by Mr. Justice Jacobs, and it dealt with two matters. Paragraph 1 on page 82 is judgment in default against the first defendant, but paragraphs 2 and 3 grant permission for service on the second defendant at 3 alternative addresses in Lebanon. So it's fair to assume, my lords, that if Mr. Saab had been sufficiently curious about the package to open it and at least to read the order, what he'd have seen was not only that default judgment had been entered against him, but that the claimant was busy seeking to achieve service on his nephew at multiple addresses in Lebanon. Now, the judgment in default elicited no response from Mr. Saab. Service on the second defendant was attempted at those 3 addresses, but without success. So the claimant had to return to the court to extend the life of the claim form and seek permission for further alternative service on the second defendant. And it's common ground that ultimately the second defendant, this was after more than a year, was formally served via service on certain Cypriot solicitors who'd been acting for him and his uncle for many years. That's GZG. That was towards the end of August 2023. And as you know, a further 4 months elapsed before the first and second defendants filed their respective applications on 21st of December. So on any view, delay was very substantial. In the case of the first defendant, that's 15 months. So let's see what he told the court in asking for judgment to be set aside. His first witness statement is at page 167 of this bundle. It's still in the supplemental bundle. His first witness statement is at 167. Most of this statement, my lords, is devoted to the substantive question of the debt and why it wasn't repaid. There are just 3 paragraphs, my lords, at page 175. Just 3 paragraphs in which he addresses the reasons for the delay of 15 months. And let's see what's said.
Should we just read this?
Paragraph
page?
46. Yes, please, my lord. It's just 46. Yes, it's just 46 to 48. So, my lords, he says, I vaguely recall being served with the papers. And then he says he's very busy with 4 pieces of litigation in Cyprus. He mentions his caring responsibilities. He says, I must not have realised the importance of the court documents. I apologise. Then in the next paragraph, he switches to August 2023, which is when the Cypriot lawyers GZG was served with the proceedings against the second defendant. And you'll notice straight away, my lords, that there is no acknowledgement that he's been personally served with the default judgment fully a year earlier. That is ignored. And you see what he says of the 4-month delay between August and December of 2023. In a nutshell, although I live in Cyprus, the majority of my liquid funds are in Lebanon, and I found it extremely difficult to raise funds for legal support in England and elsewhere. He refers to capital controls restricting the transfer of funds out of Lebanon, and he says it's been difficult to agree payment terms for solicitors and counsel. Pausing there, my lords, this is the first defendant's only sworn evidence as to the 4-month delay between August and December 2023. And whether you call it a duty of candour or just the burden and standard of proof, I say this doesn't go a fraction of the necessary distance to succeed on an application for relief from sanctions. An applicant for relief must condescend to detail. And if the case is, I, Mr. Saab, have spent 4 months seeking urgently to raise, say, £20,000 to cover the filing of an application to set aside judgment, well, the court's entitled to expect some detail on that. When did these efforts begin? What form did those efforts take? Did Mr. Saab contact any bankers? He owns a bank. In fact, he owns 2 banks. So it might be thought he's quite well connected. But if not bankers or professional lenders, did Mr. Saab speak to any friends? What efforts were made? What was it that changed at the end of the 4 months that enabled the release of funds sufficient for the paper application to be made on the 21st of December? Where did the funds come from? When precisely did the funds come? We are offered 0 detail on that. But it's... Go on.
Those are all the matters that cause the judge to say that the reason for this delay has been the subject of some evidence, but the evidence does not amount to good reason. So he rejected the good reason.
Well, that's, well, he's certainly saying it doesn't amount to good reason.
Yes.
The question then is, well, has there been any explanation, albeit not even amounting to good reason, my lord?
Well, there is an explanation. It's obviously not a very
Compelling.
compelling one, but the judge is plainly taking into account those matters and putting them into balance. And again, at the end of the day, a lot of the answer to all of this is that however much one might want to say there are principles or presumptions, all these factors go into the melting pot in the third stage of the relief and sanctions analysis.
Well, I hear what your lordship says about that. We say this goes a little bit further in the coyness. If we look at the coyness of this wording, my lord, the majority of my liquid funds are held in Lebanon. First point to note is that a minority of his liquid funds are on his own evidence, not in Lebanon. So where's the explanation for where those admittedly liquid funds, which aren't in a jurisdiction where capital transfer restrictions are in place?
Well, sorry to interrupt,
Yes.
but it's 12:10, and in a one-day case, we ordinarily expect you to sit down at 1 o'clock.
Yes.
You have made these points in considerable detail in your skeleton argument at 48 and 49, and you're saying for these reasons the material put forward was very thin and nowhere near good reason. And then you go on to say on the next page why you think the judge went wrong.
Yeah.
But if I may suggest it, unless either of my colleagues wants you to, you don't need to go through the paragraph 49 material line by line, because as my lord has just pointed out, the judge accepted that the reasons put forward were not good reasons within then to the stage 2.
I'm duly nudged, my lord. I'm duly nudged. I will move on. The submission, as you know, is not just that the evidence was wanting; it was internally repugnant. The evidence that was before the court, and we say that's a matter that the court's entitled and should put in the pot. At stage 3 of Denton, the egregious lack of frankness and candour here, whether you package that as a standard point or a candour point, is your lordship's.
Yes. Put in his written statement, I frankly accept I have no good reason for delay at all. Yeah. Is he worse off because he's tried to give a good reason but hasn't really succeeded? Well, I'm not sure where this takes us once you start saying frankness. I mean, if he says, I come to court saying I've got no good reason for the delay, but there are these other factors I'd ask you to take into account.
Well, he didn't say that.
No, but does it really matter? When the court says the reasons you've given don't amount to good reason, does it matter that what has been said could have been fuller if it doesn't amount to a good reason?
I have your lordship's point that it is what it is, and you know the court can either say, well, there's nothing here. It doesn't have to go and take the further step of saying, well, not just that, but what is said is thoroughly incredible, because in one and the same breath, evidence is being said there aren't funds, and the evidence discloses there are funds. But I have your lordship's point, and I'm going to move on to the second defendant's position. Your lordship should perhaps just spend 1 minute at page 180, because that's the second defendant's statement, and I'm duly nudged, so I'm not going to spend any time on it other than to show you a couple of evasive aspects of this. The second defendant only served the one statement. The first evasive aspect concerns the address that's given, my lord. The rule, as you know, is that a deponent to a witness statement must either give his residential address, or if he's employed or working for a firm and giving evidence in his capacity as an employee of that firm, he can give his employer's address. But this second defendant does neither. You see what he says in paragraph 1. I'm resident in Lebanon, but actually I'm going to use the address of my lawyers in Cyprus. My lords, that's outside the rules. I wouldn't ordinarily be quick to take a point like this, but the background here is rather peculiar. The claimant spent more than a year trying to locate the second defendant to serve him. And you know that you saw the various addresses. And you know, private investigators involved and so forth, and thousands of pounds spent. And after all that, my lords, the second defendant doesn't disclose his residential address, even though the rules require it. And you may say, well, what's that got to do with his entitlement to relief from sanctions? And the answer is, we say, well, in the context of applying for relief from sanctions, he's openly breaching the rules so as to seek to secure for himself an advantage, namely the advantage of keeping the claimant in the dark as to his whereabouts, making enforcement and attachment down the line all the harder. And the court shouldn't look kindly on that. It's part of a broader picture of evasiveness and cynicism, we say. But the meat of the statement starts, you see, at paragraph 6, to the extent that there is any meat, and you'll see what's said. I don't want to spend time on it, save to say that he doesn't suggest that he's taken any steps independently of his uncle to do anything. So we're in fact very much in Lord Justice Phillips' hypothesis of, I did nothing, I got no reason. And I suppose stepping back on this application, the question is, if an applicant can come before the court and say, I've done nothing, why should he have relief from sanctions? What application for relief will fail if, as this second defendant does, he can come and he can say, well, I left it to my uncle. I'll drive a wedge between myself and my uncle for all purposes of service. I won't say anything to the court about my knowledge of the letter before action and the progress of the proceedings, because I'll treat my uncle as separate for those purposes. I'll say nothing about my knowledge before formal service on me, but having been served, I know my uncle was busy with various other things, but I just tell the court that I asked my uncle to do it. Is that really enough for relief from sanctions?
Well, I think we have to, forgive me, but we have to look at the context of the relief from sanctions. All the second defendant is doing is asking for relief from it may be a very significant but he's asking for the relief in respect of the 1-day delay in failing to serve the jurisdiction application. That's all, and he doesn't have to justify what went before in relation to service upon him, does he?
Well, what I say,
he's not done anything wrong.
Well,
they say not cooperative, but he.
Well, we bristle at the suggestion that it's a 1-day point, and the authorities show you have to look at the full time afforded to him for compliance. So in this case, he acknowledged service on the 18th of September. He then nothing until 21st of December. And if he wants relief, he should explain that full time, the full time that has elapsed, during which the full 3 months that he's had for compliance, and that is underscored in the British Gas trading case. Should we look at that briefly?
Yes.
Yeah. So that's
The time he had for compliance is explained by the fact that he had extensions of time which you agreed to.
yes.
So
Yes, but he can't be doing nothing. I mean, it can't be held against my client that very reasonably Mishcon de Rey agreed repeated extensions. If he wants further indulgence from the court, it should be explained what he was doing in that time. why should he be entitled to more time in circumstances where he's already had 3 months? But the point about sorry, my lord.
As I understand it, it's common ground, or maybe not common ground, but what we're talking about here is an unless order after a whole series of
Extensions.
Which required by a particular date, and that date was missed by 1 day.
Yeah.
And I mean, the big question, it seems to me, is what approach one takes to the fact that this was an unless order.
Yes, well, I agree with that. I agree. Shall we move to the second?
I'm not sure that the detailed history of what he was doing during the period of the extensions really adds a great deal to the big question, which is, well, does the fact that he failed, possibly by error of his solicitors, to meet the 21-day time limit, is that something the court should grant relief in respect to?
Yes, I'm grateful, my lord. Shall we move to the second defendant's appeal, and just starting with the judgment now?
Yes.
The second defendant.
Yes.
So it's a core bundle, page 82 is the judgment. Paragraph 4. Sorry, I'm not in that thing. Yes, paragraph 4, I have no quarrel with. The judge recognises that the breach was serious or significant, and he'd been shown the British Gas Trading Limited case, which tells us in effect that breaches of unless orders are presumptively serious. It said that, you know, the fact that it's a breach of an unless order is a pointer to seriousness and significance. And although he doesn't spell it out in paragraph 5, he's finding that there's no good reason. And again, that was on the basis of this court's decision in Mitchell, which tells us that inadvertence and mistake don't generally qualify as good reasons within the meaning of Detention Stage 2, well-intentioned incompetence. Paragraph 6, we move to all the circumstances. There's still no misdirection. Then paragraph 7, he says in mitigation that it's an inadvertent mistake. The solicitors were trying to do the right thing. Now, it's no part of my case, my lords, that signature litigation deliberately missed the deadline. Of course not. But what was advertent, my lords, was taking it to the line in the first place. There was no justification for waiting to file the application until the 12th hour. And given the very significant delay that had already taken place, the application should have been filed as soon as possible. And that's true, my lords, as a general proposition in every case where a party has asked to extend time, let alone repeatedly. You shouldn't play the system, my lords, by using the very maximum. You should get on and serve as soon as possible. But the position here, my lords, was a fortiori. And let me show you why. And so your lordships have your chronological bearings. The second defendant's defence or jurisdiction challenge was originally due by 16th of October. A first consensual extension was granted to 31st October. A second extension was granted to 13th of November. And then, if you turn up tab 43.1 or page 263 in the supplemental bundle, page 263, which I think is tab 43.1, it was then that the second defendant applied for a yet further extension. Do you see that the application notice is dated 13th of November? And see the time frame that the second defendant asks for. He effectively asks for a further month from the 13th of November to the 11th of December. And if you turn to Part C of this application on page 266, you see what's said in support, said both the defendant and I have been facing liquidity issues, including difficulties in transferring funds. This has prevented me from agreeing engagement terms. I hope to agree terms in the coming weeks. An extension until 11th of December should give me the time I need. So that's the evidence. A few points to note here in passing. This is the first time that the second defendant has suggested that he faces liquidity issues. There's no counterpart to that in the sworn witness statement. No detail, of course. And also note in passing this sort of known sequitur between inability to agree terms and inability to pay. They're quite different things. But finally, look at the time frame which the second defendant asked for. He asked for until 11th of December, and there's no suggestion that he needs any more time. Now, what happened, my lords, was that Mishcon de Rea offered the second defendant more time than he had asked for, but by agreement on peremptory terms. Mishcon said on the 23rd of November, let's agree to an order that you'll have 21 days from the date of the order, but that's it. And if you miss the deadline, the curtain comes down. Now, so signature litigation was given until 27th of November to respond. And let me show you their response at page 273. 273. Now, 273, this is signature litigation, writing to those instructing me. Thanks for your email of 23rd of November. We attach a revised draft consent order signed by the second defendant. And, my lords, you have that revised signed order at pages 278 to 279. I think the only change they've made is that they've altered the provision for costs. Off it goes to the court, but by the time it reaches Mr. Justice Foxton's desk, it is 29th of November. So the effect of the formulation is that the second defendant will have until the 20th of December, rather than the 11th of December that they have asked for,
Yes.
and the 18th of December that Mishcons had effectively offered. So it's more time than he said he anticipates needing. And while we're here, I should probably just quickly deal with the respondent's notice on this point. It's core bundle 27.3 is the respondent's notice.
Page 21.
Page 21. The learned Fred says that another reason why the judge should have granted relief from sanctions was because the original draft of the consent order was prepared by the claimant. Learned Friend got no traction with that point below, and he shouldn't here. As I've just shown you, the document that went before the court was a draft marked up and amended by the second defendant's solicitors. Of course, it's always preferable to insert a date for compliance rather than a formula, but that's something which signature litigation could and should have corrected. Having failed to do so, and having signed a draft which used a formula, they can't sensibly be heard to complain that they've been prejudiced by their own error. But more importantly, they overlook...
They haven't been prejudiced, but their client has been prejudiced. My goodness, he has.
Well, they've been prejudiced by the decision to take it to the line.
Yes.
And let me develop that.
I
because
understand that. But
that's
could
the-
we look at, before you
Yes.
develop it,
Yes.
can we have in front of us supplementary bundle, page 88, which is
Page 88.
Mr. Justice Foxton's order.
Yes, the unless order. Yes, my lord.
And you say that the big clear seal top right saying 30th of November is as a matter of construction of the rules, neither here nor there, so that by within 21 days means within 21 days of the date underneath Mr. Justice Foxton's name.
That's common ground between below.
Yes,
and
it
yeah,
is,
yeah.
yes. And the evidence is that a junior lawyer at signature law made a mistake. Now, that's the question which has to be assessed. I entirely appreciate that all that you've said about leaving it till the 12th hour and the lamentable history, but that was the question which Mr. Justice Knowles had to decide. It wasn't a one-day error encased by with a lamentable history of, for example, somebody who can't add up to 21, as it were. It's not that sort of mistake. It's a mistake in thinking that the date of this order is the seal date, and certainly if orders come to me for approval, and I saw something like paragraph 1, I would be unhappy about it. And the respondent's notice says that that's not just a matter of instinct, that's a matter of the practice direction. That's the point you have to meet.
Yes, and it was this was a joint error by both parties, and that's, you know, it's common ground that the, you know, in an ideal world, it's Rule 291, you put in a date. Of course, it was open to signature litigation, spot the point and correct it. It didn't, but it's not really about one day, and it's very important that the court has this point. So 2 points this is about. One about the unless aspect, which Lord Justice Phillips has raised, and we need to grapple with that. What does it mean to say unless? And the other is this strategic decision to wait until the 11th hour. Can I just address you on those two points, please? And the key point is that the second defendant didn't need until 20th of December. He never claimed that he needed until 20th December. His duty was to get on with it, not to hold off cynically until the very last day, capitalising on the happenstance that he'd gained an extra 9 days, 7 of which we'd offered, and a further 2 which came by way of bonus, owing to the delay in the paperwork being put before Mr. Justice Foxton. Waiting until the final date is playing the system, and if you do that, you do it at your own peril. You are courting disaster. Parties shouldn't be sitting there with a calculator working out, well, the last possible day that we can file is Thursday the 21st. So working back from there, let's leave it until Tuesday the 19th before we put pen to paper. That's just not acceptable. We would say in any case where time has been extended, but certainly in every case where repeated extensions have been granted. But that is what the second defendant did here. He didn't just wait until the last day, my lords. He waited until the last 30 minutes of what was thought to be the last day. If you have the supplemental bundle anywhere near, page 298, if you have page 298 of the supplemental bundle,
when you say playing the system and waiting until the last minute, we're only here because it's a day late. So what do submissions like playing the system, waiting until the last minute, what do they add to the fact that it's a day late?
Well, the submission I'm developing is that what's happened here is that rather than getting on and filing the application as soon as reasonably practicable and recognising the inconvenience already caused by the failure to meet the time prescribed by the rules, there's been a decision to wait until the 12th hour, and the very 12th hour, which, as you see at page 298 at the bottom, if you have the bottom third of the page, Mr. Gavin Collins at signature litigation is emailing at 4:06 in the afternoon. And he doesn't even manage to get the exhibits in, or indeed a legible copy of the first defendant's witness statement. If you scroll up, you can see how that unravelled. But this is because the second defendant held off in a way that he shouldn't have. And your lordships may have this point, but the second defendant just let matters drift and drift and drift. Can I just show you briefly at 254 how that evolved at 254? So do you see on page 254 that on the 27th of September, so that's just 9 days after filing the acknowledgement of service, Signature wrote asking for an extension from 2nd of October to 11th of October. So and you see that in paragraph 2 on page 254. So at that stage, Signature is contemplating finalising terms within a fortnight. In fact, they'd simply misunderstood the rules. So if you turn over to 255, those instructing me very properly pointed out that the second defendant was entitled to until 16th of October and invited Signature litigation to think again. Signature litigation thought again. At page 256, they next proposed 31st of October. Again, 257, Mishcons agreed. 259, Signature litigation asked for more time. Mishcons agreed again, and the rest is history. And against that background, though it's particularly galling to hear it suggested that Leadingway has acted opportunistically. Leadingway agreed 3 extensions. It pointed out Signature litigation's misreading of the rules, and the duty of cooperation laid down by the CPR doesn't require a party to compromise its own rights indefinitely. There must be finality. So when we come back to the judgment at the core bundle page 83, where the judge says at paragraph 7 that Signature litigation was trying to get the timing right. Well, we agreed that they weren't setting out to miss the deadline. We disagree that you get the timing right by planning not to serve until after 4 p.m. on the very last day, and that should go into the pot. That should go into the pot. Paragraph 8, of course, I'd addressed the judge on the problems with the evidence, and as you pointed out, he broadly agreed. I'm troubled at the limited evidence. It's not as full as I wished. And then he says it's fair comment. The second defendant's left everything to the first. Pausing there, judge is with me on the unsatisfactory aspects of the evidence. He accepts that it was wanting. He also accepts that the second defendant's left it to the first. But as to the landing that the judge reaches, you see it at paragraph 9. He says, I can't accept that a just approach is to refuse relief from sanctions, but with no reasons why, and at least no express recognition that it was for the second defendant to persuade the court that the grant of relief was in order. And in this respect, the two appeals have much in common, because the findings are in each case a serious breach, no good reasons shown, and then relief is granted, but with no clearly articulated explanation. The only countervailing consideration identified in this judgment is what's said in paragraph 7, that there was some well-intentioned incompetence, but that can't carry the day for 2 reasons. One is because, for reasons I've developed, we should never have been in a world where anyone was calculating the very last 30 minutes during which filing could be achieved. And then the second, well, as to the absence of a deliberate breach, well, obviously where that happens, the breach isn't aggravated. So to that extent, it's a mitigating factor. But incompetence can't of itself be an affirmative reason to grant relief from sanctions, and certainly not when what's at issue is a very significant delay of 3 months odd. Which brings me to the second point, and I'm coming to your lordship's point about the unless order, my lord, but just can I deal briefly with my learned friend's second point raised by the respondent's notice, and this was the seriousness of the breach. My learned friend wants to persuade you that it was wrong for the judge to recognise that the breach of the unless order was serious. I say plainly it was serious. The authorities are clear that when you're assessing the breach of an unless order, the court doesn't focus narrowly on the margin by which the deadline is missed. The court looks at the full opportunity given to the party for compliance. Would it be worth spending a moment on BGTL?
Yes,
Yes,
I think
okay. So it's tab 17, my lord, of the joint authorities.
it's only 3 or 4 paragraphs.
Yes,
in it.
exactly. It's from paragraph 34. It's 34 to 41. Should I leave your lordships with that?
Yes.
Yeah, so the principle is very clear. You don't look at the breach of an unless order in isolation. You look at the full opportunity afforded for compliance, and you know, an unless order is the fact that it's a breach there is pointed towards serious and significance. My learned friend.
Do you guys away from the fact that this isn't just an unless order made by the court, but it is an agreement?
Well, that's the point, my lord. So on the one hand, we say that you've got a legitimate expectation that if the time comes and goes, that's an end of the matter. It's going to be enforced. But it's not just an expectation. Here, my lords, critically, it's our contractual right. That was the agreement between Leadingway and the second defendant. And if it was any other agreement, this court wouldn't dream of interfering. There's no duress here. There's no incapacity or fraud or mistake or any vitiating features which would entitle the court to strike down the bargain. With the benefit of legal advice, the second defendant reached an agreement, and if this court upholds the judge, we say the court is unjustifiably unravelling a commercial bargain brokered by experienced litigators. And it's not just a matter of contract, though that is a very important factor. You're going behind the order of Mr. Justice Foxton. It was for him to decide whether the sanction agreed between the parties was appropriate. And I don't want to overstate the position, because no doubt Mr. Justice Foxton had a dizzyingly high pile of papers that he had to get through. But it would be wrong for the court to proceed otherwise than on the basis identified by Lord Justice Moore-Bick in the Marcan shipping case, namely that before it makes an unless order, the court gives careful reflection to the sanction and its proportionality. And I say it would be wrong to proceed on the basis that Mr. Justice Foxton had, put a rubber stamp without giving any thought to the contents of the order.
Well, in the case of a consent order, the judge is entitled to take the view, isn't he, that as the parties, in particular defendant, has agreed to that,
Yes.
as the consideration for further extension of time, to spend very long on that.
Yes. I mean, obviously.
But it doesn't.
And speaking for myself, I think your more powerful point is this is a contract.
Yes.
if Mr. Justice Fox, I don't think that Lord Justice Moore-Bick's case can simply be carried across that a judge approving a consent order between grown-up people, commercial litigators, need consider what really an unless order, is that proportionate?
Well, I suppose, my lord, that does call into question a broader issue of what the court is doing by approving the order. Did we get nothing by the court's seal? Is that the position? I mean, if it is, it's still, as it were, fine by me, because I say that it's a contract, and on established principle, there are categories in which the court will intervene and interrupt a party's bargain, and we're not in any of those categories, so it's exceptional. If all we've got is a... Sorry.
I'd just ask you this. The starting point is that even if it hadn't been an unless order, you would still, they would say it's simply extended time to the 20th of December, in which case probably the practice direction wouldn't have applied. But just to say it's extended time to the 20th of December, it wouldn't have made any difference, would it, to the consequence, because they would have been out of time to make the application.
That's right, that's right.
And they'd also been out of time to serve a defence.
Yes, because
So
they're equivalent.
Really, it's a point in your favour. The point is, given that if there'd been a mere extension of time, they would still have had to come and ask for relief from sanctions.
Yeah.
So what does it mean that it's been agreed by the parties that this is an unless order? Plainly, the parties are agreeing something more than that they have to apply for relief for sanctions.
Well, we completely agree, my lord, and it's.
What you might.
Well, yes,
Right.
but I do.
But you don't have to say why you agree.
No.
Ms. Bingham, have I got it right? Tell me if the way you put the argument is this, applying the Denton stages. Denton stage 1, is this serious and significant? Yes, conceded as such, judge agreed, and the reason why it's serious and significant is because it's an unless order, see British Gas. Good reason that the solicitor made a mistake? No, as a matter of law, you say, see Mitchell. So then on stage 3, all the circumstances, you pray in aid that this was an agreed order, so it's in the nature of a contract, and you draw attention to the long history of extensions and extensions and extensions, and you say that an agreement was made and the judge did not explain why he was in effect setting aside the agreement. Is that what it comes to?
Your lordship has it. Just and in 2 further sentences, what is the unless bit doing and the consent bit doing, unless it's doing what I say it does? Part of the point of the unless order is to capture the target's attention and coerce compliance. It is the last chance saloon. And if you say, well, in reality, the last chance saloon has various antechambers, and if you get there within, 30 minutes or an hour or 3 hours, you'll be fine. Well, where's the principle cut off? And in some cases, of course, it's possible for the innocent party to point to a compressed time frame created by the breach or a vacated hearing date, and those are paradigm and easy cases of tangible prejudice. But equally, there are lots of cases of breached unless orders where case management directions haven't been given, so the court's diary and the parties' diaries aren't being mucked about. It doesn't mean you're not suffering prejudice. We had a negotiated bargain here, and that bargain should be respected by the court. So I say, as your Lord Justice Bean identifies in the round, the judge identifies nothing of substance which ought to have tipped the balance at stage 3. And if finally we just turn up the grounds of appeal in the core bundle at 14.3, 14.3, Ground 3A speaks for itself. Likewise, over the page, little b needs no commentary. Little c, I've been addressing you on. Incompetence might be a mitigant, but it can't single-handedly carry the day. D is candour or fullness that I've laboured considerably, and E speaks for itself. My lords, unless I can assist you further, you have the submissions for Leadingway.
Could I just ask you one thing,
Yeah.
just to understand the context a bit better? I appreciate it's not an issue on the appeal, but your claim substantively.
Yeah.
Can I just understand the interrelation you say between your agreement and the written agreement? As I understand it, the written agreement is dated in March, but was signed by your client in October.
That's right.
The oral agreement is alleged, or the conversation which is said to give rise to the oral agreement happened in July, in between those two dates.
Right.
So it's not clear to me. Are you saying that there was the written agreement, then the oral agreement?
I think that the timing, my lord, and apologies, I think that the timing, I'm just looking back on it. That's right, the letter is sent out. In the meantime, there is the oral agreement, i.e. before a written agreement has been concluded. There is an oral agreement, and we treat the written agreement as further comfort. You see that, I think, in paragraph 9 of the written agreement. Paragraph 9 of the particulars of claim. The written agreement is superimposed. It comes after the oral agreement, and it's written comfort. Independent, but it does form an independent agreement, and that is how the case is put.
Right. It's page 208 of the supplemental bundle.
Are you looking at the written agreement, my lord?
Yes.
Right.
208. So what was written on the 22nd of May was, we have always maintained that we intend the obligations of the company be met in full, and you will receive your dues by the 1st of September 2019.
Mm.
And then in consideration, so that's the background. In consideration you agree not to file or pursue any claims in the liquidation of the company, the Saab has made the following commitment to use a backup. So that's a backup to receiving your dues by the 1st of September 2019.
By way of personal covenant, as we would say, yes.
Where then do you get from this agreement a further promise to pay by September 2019? I think you plead it's paragraph 3, but I'm not quite sure.
So we plead that paragraph 3 amounts to a warranty that the putting into place the arrangements described above will result in payment. That's how it goes, my lord.
Yes. As I understand it, it's saying, well, we're saying you're going to get it by September 19, but the backup will put this arrangement into place by which you'll get your money back. I don't understand that to be saying you'll get it back by the 1st of September 2019. So, as I understand it, saying if you don't get it back by 2019, you'll get it back by this year, which is relevant to the properties.
Well, my lord, I don't want to add to the to the pleadings on this. I'm not sure that would be right.
Okay, I just wanted to just understand just the background.
Yes, I'm grateful.
Right, thank you very much, Ms Bingham. We'll hear from Mr De Cruz at 5 to 2.
Court rise.